Hi, this is the first in a series of videos about digital land registration. Um, this one will present the initial conceptual overview. Hope you enjoy it. So, what is a land register? So, a land register is an official record describing rights in land, principally framed through ownership rights. The information recorded and the protection provided by a land register will vary by jurisdiction, i.e., each country has its own laws about land registration. So in Scotland, for example, the Land Registration Scotland Act 2012, section 1.1 states there is to continue to be a public register of rights in land in Scotland. So, as you can see, all of the major food groups are there. You have rights, you have land, and these pertain to parties who are registrable. So, all of our core concepts are contained within that one sentence. These concepts are also fundamental to the land administration domain model. That's ISO 19152. So, why would you have a land register? Well, a land register formalizes the relationships to land, and these become increasingly important as societies develop. And ultimately, these relationships become so formalized that they're enshrined in law. And a land register is a reflection of that legal relationship. So, as described by Enmark, McLaren, and Lemon, land administration is about people. It is about the relationships between people, place, and rights, and the policies, institution, and legal regulations that govern this relationship. So it's about that social construct. So, what happens? It's always nice to go back to the beginning. So, in the beginning, land was granted, and that's normally by a higher authority. And so, in the UK, for example, it was by the Crown. And eventually, that new owner of land may want to legally transfer that right in land. And to do this, they use a deed. And a deed represents the legal enshrinement of the transaction. So it formalizes changes to a party right and land relationship. So a holder of rights in land, a grantor, legally transfers some or all rights to a third party, a grantee. And that is witnessed and delivered. But how does a buyer know that the seller really owns the land? I mean, land is quite a serious investment. It's one of the largest things that people will potentially invest in their lives. So, in common law, and again, this goes back to the UK, ownership can be demonstrated by tracing the chain of ownership back to the earliest grant of land. Each ownership change is associated with a legal instrument, normally a deed, as we've just seen in the previous slide, and this collection of deeds that demonstrate the chain of ownership from the first grant is called the title deeds, or chain of title. Demonstrating ownership through this chain of title demonstrates the owner has indefeasible ownership. And indefeasible is defined by Pamela O'Connor, but in the following way: an indefeasible title is one that cannot be set aside on the grounds of any defect in the way that it was acquired, i.e., you are the true, real, and absolute owner of this land. And so here we are, is how we determine our chain of title. So, the Crown grants a piece of land, and that land is sold and sold and sold and sold and sold and sold and sold until it gets to the current owner. And the fact that you've got all of the deeds that trace the sales back to the Crown, you have indefeasible ownership. And so whoever you want to sell it to, i.e. the grantee in your new deed, can say, yeah, that's all very solid. I agree that you are the real owner. Everything is fine. So that indivisible title means that there is no legal ambiguity concerning ownership, and the indivisible title is safe to be transacted, and that is core to a conveyancing system. So what happens if the chain of title is broken? So, for example, the Crown grants some land to someone, and they write a deed, and it goes to somebody else, and then they write a deed, and it goes to someone else, but that deed in the interim is burnt in a fire. And then if that deed goes on, it goes to someone else and then passes down, but one of those deeds is stolen, and then it passes on, and one of those deeds is lost in a flood. So we have our fire, theft, and flood events. So when the current owner of the land tries to sell the property, there's uncertain ownership. You cannot demonstrate indefeasible ownership, and that represents uncertainty, which becomes a problem for a sale. So, what do you do about that? Time to bring in the land register. So that basic principle of a chain of title is demonstrating that you need to demonstrate ownership. So you cannot sell what you do not own. So effective conveyancing requires the seller to demonstrate this indivisible title, and that's difficult when the legal instrument representing the chain of title is stored in different locations. So in theory, it would be much simpler to publicize the legal instruments through a registration process. So if all of these transfers of interest were registered at a public office, then they could be easily examined and ownership could be easily ascertained. And this is essentially the thinking that underpins a land register. You're formalizing the land register and registration law. That means that if you're going to sell property, what you do as part of that sale process is put the deed that describes your sale into a public register. Otherwise, that sale is not legally valid. And so to do that, jurisdictions produce registration law. And this provides the ability to register legal instruments that describe the transfer of ownership interests and the granting of other rights in land. And registration, as I just mentioned, under registration law is encouraged by declaring that ownership cannot be legally transferred without associated public registration of that legal instrument. So if we get back to our earlier example, here we have the Crown granting land, and then there is a deed that represents a sale, and that deed is registered in the public land register, and then someone takes a copy of that and they create a new deed for another sale, and that is registered in the public register, and it goes on and on and on and on and on. Now, some of the original deeds are destroyed through fire, theft, or flood, but that doesn't matter because the public land register registers copies of the deeds, and so you can determine indefeasible ownership by looking at the copies of the deed in the land register itself. And so you have this belt and braces approach to land registration. Hooray! So now that you have your chain of title, or your ability to derive your chain of title, you have this collection of legal instruments from which you can determine that chain of title. You then get into a search problem, and this is described effectively by Professor Mapp in 1978. The administrative efficiency of an instrument registration system and its indexing in particular is of enormous consequence to lawyers, other professional searchers, and the public. So national registration systems and public servants effectively act as land librarians, registering land change and indexing land knowledge to maximize retrieval. This whole indexing process becomes very important, particularly so when we get to talk about torrents later on. Okay, here endeth the first lesson. We'll be moving on to land registration in a little bit more detail in the next presentation.